Okay. So when preparing proposed orders, we have a bankruptcy local rule that tells you exactly what you need to do with your prepared orders. If you submit something to the court and you get an email or call from one of the folks here in our chambers, this would often be from Monique, our courtroom deputy, one of the first places she may direct you is to look at the local rules. So make sure that what you submit to us is formatted appropriately. And that includes the relevant information. This includes if a matter was scheduled for hearing, even if there was no reason for the judge to come out on the bench and hear it, it still needs to be included in the order that you submit to the court. If there are any problems with the order and you receive a call or email, please be prompt in responding to the court. And this goes for no matter who contacts you. It doesn't need to be the judge or the law clerk. If the courtroom deputy gives you a ring, call them back as soon as you can. Again, you want to get that relief for your client, so make sure that we can help process those orders quickly. This is a big thing. Do not add anything in your proposed order that was not originally asked for in the motion. So for example, if you're filing a motion to reopen and the court considers whether it's going to reopen the case, it can only just reopen the case. It's not going to reopen the case and grant a lien strip or something else. Really be careful that when you file a motion, your prayer for relief includes the request for all the relief that you are seeking. So those are things kind of specifically about making proposed orders. This is more generally when you're filing proposed orders, when you are filing motions, you're preparing anything in an adversary proceeding or bankruptcy case. Before you go anywhere, really, you want to make sure that you are familiar with the local rules and the bankruptcy rules. Both the federal rules of bankruptcy procedure and the local rules include a whole host of information about procedures that you need to follow for motion and trial practice. So for example, you need to mail an objection to claim 30 days before the hearing. So that's kind of a random one, but it's right there in the rules. We often get something comes up one reason or another, an attorney wants to or needs to withdraw. There's a very specific procedure in the bankruptcy local rules, 9010-5, that deals with this. And there are certain situations in which a motion is not required, which you have a stipulation, and that's also covered under the local rules. So make sure that you review those. And on the court, if you have a question as to whether there's even a rule about something, you can always do a quick search on the court's website. The court's website, ganb.uscourts.gov, also contains individual judge web pages, some of which include specific requirements, forms. So for example, if you ever file something, you're seeking emergency relief, you want a really quick hearing on something, there are procedures that explain how to do that on the court's website. Judge Mullins has specific rules also regarding if you have an evidentiary hearing, you're going to need to get things in advance, and that will be discussed on the court's webpage. Do not call chambers to ask questions that could easily be answered by checking the local rules. So you want to know when a responsive pleading in an adversary is due. You want to know the page limit. That is dealt with. And one other procedure in negative that's dealt with in the local rules is negative notice, for example. Do not put, this is a personal thing to note, but do not put the deadline to respond to a motion as the same date as hearing. That is not how we do it here. They need to be separate dates. You need to have the deadline for responding to be before any hearing date. All right, the next pleading piece is every claim must have a sufficient factual basis to award the relief requested. So this means that if you're filing a complaint, initiating an adversary proceeding, every claim must be supported by sufficient factual detail to support each element of the claim. This is the same if you're filing a motion. If you don't thoroughly present the relevant facts to justify the relief requested, we can't grant them, even if there's no opposition to the motion. Oftentimes, we have so many different cases here, so many motions, that I think this kind of gets glossed over. You need to make sure that the court can grant the relief that you seek. If you put this in there, it's going to make everything much more efficient for you, for your client, for the court. You're not going to get things kicked back, and it really helps speed things along. While you are providing facts, focus on the relevant facts. This is particularly problematic if we have a case we often have here with really contentious background history. Maybe it's been pending in state court for years. Maybe there's a domestic dispute and there are a lot of hard feelings, a lot of heated debate as to what actually happened. But what is really at issue that the court needs to focus on? So make sure that personal grudges and bad feelings don't get in the way of what you put in motions or pleadings filed with the court. Again, the reason that you don't want to do that is that they can be kind of a distraction, and you want to make sure that you focus on the relevant information for the claims that you filed. And finally, help the court, please, by providing legal authority. Accurate and helpful legal citations go a long way. The court wants to not only check and verify what you've submitted, but make sure that it's on track with its legal analysis. And the Blue Book is something that many attorneys deal with in law school. Really, in bankruptcy, we are only using we're only citing to a few things. There might be rules or cases. That's kind of it. Occasionally you'll have something else. So if you're an attorney in your office, just have a Blue Book, and you can highlight the particular rules that come up, maybe flag them. Basic citation form for a case. We often may be looking to cases that aren't cited in a reporter. So the first example up there is to a case that's available on Lexis. Note that you'll need the case name and the case number. Another citation that we often deal with is anytime that you have a contested matter or an adversary proceeding, you want to cite that, and then in the parentheses is the debtor, the bankruptcy case name. Oftentimes we'll just see the case name when it really is an adversary proceeding or a contested matter in which the dispute or the case arose. And the reason that all of this is helpful or necessary is it really just directs the court exactly to where the citation, the authority that supports your position is. It helps cut down on time for us, but it really makes your case also a lot stronger. But a big point is to make sure that it's the applicable law. A lot of times we'll get cases citing to Georgia law without explaining in any way why that's relevant. So when you're picking authority, explain to the court why that's the right choice of law, and think too that your argument is only as persuasive as how well it's supported. So bankruptcy opinions from the 11th Circuit are great, best authority. We have access to all these different cases from all over the country online. Well, if you're citing it to us, there better be a good reason why. Is it particularly helpful for its analysis of a dispute? Is it kind of the preeminent example of something? You want to really, get the best authority for your position. And you don't need to include a whole string cite of cases. Just pick the one best case that supports it. And all of these pleading notes are really meant to just help you create a motion that when the court reviews it, we can kind of check all of our bases and grant the relief requested if necessary. So things just to keep in mind when you're filing motions, pleadings, complaints, and the like in our court. And thank you all again for coming. That's all I have.
You can ask for questions.
Questions? I can also, if you have any after, you can come. Feel free to ask me. But that's what I got.
No, I didn't see online. I can unmute them. Oh, you don't have
No.
Oh.
No. I was going to explain why I don't have
Okay.
a PowerPoint. I'm Janine Treese. I'm one of the trial attorneys with the U.S. Trustee's Office. I don't have a PowerPoint. I apologize. I was very busy last week with trustee training and preparing those materials. Lindsay Kolba is the attorney that y'all probably know who does most of our means testing outreach and explanation. So I'm standing in for her today. She had a conflict today. But I was able to come up with a top 10 list for means testing errors. But before I go into that, something came up at trustee training Friday that I wanted to go ahead and let y'all know about before rumor mill starts. In Chapter 7 cases, when a debtor has not presented his or her tax return prior to or at the 341 meeting, and the trustee continues the meeting to give the debtor a chance to present the tax return, the debtor must come to the continued meeting. The trustee cannot excuse the debtor's appearance at the continued meeting. And the reason for that is because the debtor must testify under oath, on record, the tax return that's presented to the trustee is a true and correct copy of the tax return that was actually filed. And that is why the debtor must be at that continued meeting. So I want to let y'all know that. That's, has it? Okay. Well, that's the reason, is because that's a mandatory question that must be asked. And it can't be asked if the debtor's not there. All right. So, means testing. First thing, this is my stand-in for PowerPoint. Old-fashioned. Current monthly income. All right, so the very first thing is current monthly income is a calculation. So that means that counsel should be putting pen to paper or finger to a calculator to determine current monthly income. You have to add and then divide. You can't just take one payment advice or just ask the debtor, what's your average monthly income? It actually is a calculation of 6 months worth of income divided, right? The only exception to that would be if you file a case in July and the debtor has, the debtor's only income is from the job that he or she currently has, and they've got a 6-month June 30th payment advice, and the debtor doesn't have any other income, right? But other than that, you've got to do some calculating. Second thing is current monthly income again. Current monthly income is not just income from your job. It's income from lots of sources, right? It doesn't matter whether it's taxable or not. So part of calculating current monthly income is to engage in a Q&A with your client about all sources of income during that 6-month period. Next thing is student loans. Student loans are not priority obligations, so they're not deductible on line, whatever it is, 35 of the meeting. The numbers have all changed. I don't have these memorized anymore. So it's not deductible on line 35 of the means test form. The next one is, I'm making a mess. Non-priority taxes. Only priority taxes are deductible on the means test, right? So a lot of times we get into this big question and answer with debtors' attorneys about, is the tax that you've deducted on the means test deductible? Is it a priority tax? So when was the tax incurred? You've got to go back to the definition of what is a priority tax. Sometimes we try to look back on Schedule E and see what you got listed there, but then sometimes people put things on Schedule E that are wrong on Schedule E. So if you've got something listed, if you've got a deduction for priority taxes, we're going to ask about that. we're going to want proof that it's really a priority tax.
Yes.
Judgments, right? The bankruptcy code says that generally the monthly expenses of the debtor, things that are deductible on the means test, does not include payments for debts. And there are a couple of exceptions. One are payments that are contractually due to secured creditors. But judgments do not qualify, so we don't want to see judgments deducted on the means test form. Telecommunications, that's another common error. Remember, telecommunications, there's only limited items of telecommunications that are separately deductible on the means test form. A lot of telecommunications expenses are included in the standards, the housing standards. So be sure, and when you do deduct telecommunications, be sure and itemize them so that we know that you're not double dipping. Okay? Same thing with medical expenses. There's a standard for medical expenses, so we want to make sure there's no double dipping. So when you have a separate medical expense deduction, we want to make sure that you've taken into account the standard. So we usually will ask for proof of medical expenses. And this should be an average, right, not some one-time expense. All right. Documents. Certain line items on means test form require that you present documents to show that the debtor has extraordinary expenses. Be sure to bring those documents to the 341 meeting and let the trustee collect them and turn them over to us. Charitable contributions. Be sure that you verify that the debtor has charitable contributions. And you may want to make sure that there's internal consistency. So you're going to want to look at Schedule J and see, is there an ongoing charitable contribution being made? Look at the debtor's tax return, see if there's a history of charitable contributions. And then tie those and make sure those are in agreement with the amounts you've listed on the means test form, because that's what we're going to do. Right. And finally, line 43. That's that free-for-all section at the end of the means test where you get to tell me about special circumstances. It'd be helpful if you go ahead and use that line so that we know ahead of time and we're not spending an hour developing a list of documents we want you to give us when if we just looked at line 43 it would say, oh, this case is not worth pursuing because there's a special circumstance there. So go ahead and nip it in the bud and tell us about special circumstances. And while I'm on it, if we do issue an inquiry and ask for a bunch of documents, if you know of some special circumstance or change in circumstance, go ahead and pick up the phone or shoot us an email and say, look, happy to present those documents that you've asked for, but you might not want to be wasting a lot of time on this case, and here's why. We don't want you to spend time. We don't want to have your client spend time rounding up a whole bunch of documents in a case we're not interested in pursuing. So communication. All right, any questions? Thanks. Thank you. Sure. If we didn't get any questions.
You can ask, but what do you
Okay.
do you want to ask longer in here than what? Do you want to have 30 minutes?
Well, it's good to see so many of you here today. My name is Fred Childers, and I've been around in and out of this building for almost 30 years now. Emery's smiling back there. But I don't know most of you, which I guess means that I'm getting a little old here. So thank you for being here today. We do hope to make this an ongoing series of events. So be on the lookout for those. Before Laurie and Dan speak, and I introduce them, how many of you take advantage of the court's little green eye, what we call the little green eye? How many know what the little green eye is? Okay, I'm so glad you asked. From our web page, from our website, and also if you are in CMECF, am I correct, Laurie, then you will see across the top a little green eye tab. But if you are on our website, the external website, ganv.uscourts.gov, look at the CMECF tab, And under that, on the link for the CMECS tab, there will be a link that says Online Procedures Manual. So I hope that you will use that, those that have used it. I think it gets good reviews. It's a step-by-step for each docket event of the correct procedures for docketing that. So that's one takeaway tip for today to settle the handout. Use our numbering eye. So again, from the best place to just peruse it would be from the CMECS tab, Online Procedures Manual. I'll put you on the spot, Nate, if you can raise your hand. You used it and it's good. Okay, so that's takeaway number one. The PowerPoint that will be on our website after the meeting today. So, and I have some copies of what we're going to go through now. If you want to share these, if they help you along the way. But again, these will be available on the website after the session today. One of our big projects for the year is in CMECF, as you are docketing events, we started updating prompts, trying to make even more information on the prompts to help you. So be on the lookout for that. All right, that's all I have to say. But many of you remember the name Irene Wiggins. It's been around a while. And Irene retired a year ago, but as our CMECF guru. But we're happy still to have Dan Newsom, and his extension is at the end of the PowerPoint there, 1099, as well as Laurie Davis. And they both are on our CMECF team. They will give you information today about their phone numbers, as well as group email address if you have questions. And they're going to take you through this now what we see, at least, are the top events where there are errors or things that we could improve on for CMECF docket. So, Laurie and Dan, take it away.
All right.
All right. Well, now that Fred's covered about half the presentation. All right. As Fred mentioned, we're going to be talking about the top 5 filing errors that we've been seeing. We want to answer all your questions, but if we could just get through the PowerPoint first, we'll come back around and answer all your questions. Okay, so the top 5 filing errors. Number 1, using the wrong event. Number 2, failing to add creditors. Number 3, choosing individual or non-individual. Or adding parties. 5, capturing multiple events in one filing. So first, there's 2 ways you can find an event. You can use the search feature on the blue menu bar after you've logged into CMECF. You can type a keyword or partial word, such as with the, and it'll give you all forms of the word withdrawn. You can use the Online Procedures Manual, also known as the OPM or the green eye. It's also available on the blue menu bar when you're logged into ECF. Okay, the OPM may also be accessed from the court website. You might also want to save a link up to that, the link to that onto your on your desktop. So it might be easier to refer to in the future. Okay, when you're on the OPM landing page, you may use the search function by typing in keyword or partial word, or you can use categories such as amendments. We have conversions, motions, notices, statements, and schedules. You might want to just take some time and look through those. I think you'll find them very useful. Okay, the event that you select will contain a number of useful links, explanations, and information. Each heading will contain the most current procedure date. It'll have any local or official norms. It'll also have a link to any rules or code sections. Underneath the heading, you'll see an overview, filing requirements, and docketing section link that pertains to the event you're looking at. First, the overview section will contain a brief explanation of the event and when to use it. It'll also lead you to other similar events that may be more appropriate for what you're filing. So, for example, on the amendment to voluntary petition, instructs you to file the amended D-121 as a separate document, and it refers you to the event you should use to docket it after you've finished docketing the amended voluntary petition. Okay. The filing requirements section will tell you what is required when filing the document. It could be simple as the amended D-121. You just need an amended Form D-121 with signatures. For a motion to redact personal identifiers, it requires more. In addition to the motion, you'll have a $25 filing fee. You need the redacted document, which is filed as a separate attachment to the motion, certificate of service, a proposed order, and it also gives you a note that if you're filing an amended motion, you will not be charged the fee as long as you're requesting requesting redaction of the same document identified in the original motion. Okay, the docketing section will provide you with step-by-step instructions for docketing events along with some helpful reminders or notes. These are some examples of some incorrect events that have been used recently. We have somebody file a change of address as a notice. We've had a withdrawal of objection point as withdrawal of claim. We've had motion for voluntary dismissal of adversary filed as a withdrawal of document. Obviously incorrect. So if you use the online procedures manual or the search function in ECF, it will really help you find the event you're looking for. Okay. And number 2 error, failing to add creditors. When you're filing an amendment to Schedules D, E, and F, there are 2 ways for you to enter creditors after you answer the question, are you adding creditors? It also reminds you that a supplemental list of creditors is required, and it must only include those creditors being added. The first way to add creditors is during the docketing process. There'll be a screen with a fillable field for you to enter each creditor. Copy and paste may be a problem. Character recognition is not always accurate. Do not use Google Chrome as your browser, as it has not been tested as being compatible with the ECF.
Sorry. Where are you?
Go back. Okay, and you need to review the names and addresses for accuracy prior to clicking next. Okay. The second way to add creditors is after the docketing is complete. Sometimes it's difficult to remember to do that, but we do have a prompt that says immediately after docketing the amendment, you must upload your creditors. You can do this under creditor maintenance using the upload of list of creditors link. The supplemental list of creditors must be saved in a TXT format, not PDF, TXT, in order for them to be uploaded correctly. And don't upload creditors without first filing an amended list of creditors or amendment to DERF, because if you add a creditor, you're going to be charged a fee, regardless of whether the amendment was filed. If you selected no as the answer to the question, are you adding creditors, you must explain what is being amended. Don't simply type schedule. We know you're amending schedule. You need to type more of an explanation, like you're moving a creditor from Schedule D to Schedule EF. An amendment fee will be charged even if you're not adding creditors. You can see the bankruptcy miscellaneous fee schedule for when the fee applies. Now, Dan?
Just so we don't completely bore you to bit. Change it up a little bit. Okay, at this point, we're going to talk about choosing individual or non-individual when you are filing documents and forms. When you're, some of our documents, when you are going through the document process, require you to identify which it is that you're filing. And remember, individual is a single or joint debtor case. Okay, simple enough, right? Non-individual, corporation, or business. Okay, you can also denote those by LLC, Inc., or whatever on there. When you get to filing, like the declaration form or the summary, it is imperative that you identify which you are filing. Okay, because if you file a non-individual in an individual case, that is an error. Okay, we have to then go through and fix it. There's errors that have to be made. So when you're going through and selecting the form, just please select the appropriate form. Okay. Creating and adding parties in ECF. This is a biggie. It's been ongoing for a while. And what we're going to do here is hopefully break it down into something that you can keep from memory. We only want the core name to be stored in ECF. Okay? When we get filings, we have, and this is just an example, the Ocwen Loan Servicing LLC as servicer for, it goes on and on and on. Successor and interest by merger to. These are things that we don't need in the ETF database to identify the party. Use only the core name, Ocwen Loan Servicing. Okay? All of these extra things take up room, and they can also cause forms to fail. Okay? So there's a couple reasons we don't want you to do it other than it's just not necessary. Another example is the Bank of New York Mellon. Again, you can see all of the name extensions here that keep going until they ran out of room. But the core name that should be used in ECF is the Bank of New York Mellon. Okay? This other information is not necessary. Save your fingers. Okay? Do not use any of the following characters. These do cause failure in service mainly. Okay? The quotes, never use those. Parentheses, type, and the percentage sign. Those will all cause problems somewhere along those ways. Forgot my folks out here inside. An example that we have here is Fannie Mae is many times entered with both the quotes and the parentheses. Well, you put in the literal text of this, but our system translates it to this because these are considered syntax error or syntax commands, and it's looking for a command, a program. Okay, so that's the problem with using these symbols. So just defer from any symbols, and please never use the quotes. Creating and adding parties. When it is possible, or you're in the database, you're getting ready to pick a debtor or a creditor or whatever, please search the database, the name in the database first. Okay? Because we don't want you to keep adding to the list of Wells Fargo. As you can see, go back one for me, please. As you can see, they're in here many different ways, okay? And it just keeps building and building and building, and there's no end. What we would like for you to do is simply pick the one that matches how it's styled on your document. Then, if the record has an address associated with it, is that the address you want to use? If it is, then select it. If it's not, go back and pick another one. You will find one that has no information associated with it other than the name and the role type of creditor. That's the one you want. You can pick that record and make it your own. Okay? And moving forward, if you find a record that has no information, that's the one you want to choose because all you need is the name and the role type creditor. Okay? So don't keep adding parties to the database when you find a record like this and it fits what you can use, because by you making the submission, when you're logging in, it's going to now join you up with this party. You will get notice on their behalf. Okay? So it's, this is all you need to look for is a blank field. Now, if they have and they're asking, you do want them to get separate notice, you would then type in their address, not yours. Okay? So we're trying to keep noticing costs down, so we don't need to send you a copy of something you're going to get in email. Okay? All right. Do not create a new party unless you cannot find the name in the database. Choose an existing party without an address. So that kind of just back to what I was just saying. Choose it because the name is correct and the role type is correct. All of this other information is not pertinent to what you're going to do. Okay? By you picking this party, you are now, or that's your client, you will get noticed as their representative. Okay? Next. When creating a party, do not use care of your name and address. Again, it's going to send out a paper notice, and you're already getting electronic notice. So it's additional noticing and cost for the court. You will receive notices as their representative. So when you are in the database and you find that party, this role or name and the role type are all you need. We do not want / we do not want you to type in your firm and your firm's address in there. Okay? So, big no-no. Capturing multiple events in one filing. Okay? We have the ability to file multiple documents in one submission. Okay? And that's what we want you to do. You should file, let's say, when filing the remaining documents to complete a petition or amendment, you should file them in one entry by holding down the control key. When you're in ECF and you're at the screen where you can choose the available event, by you holding down the control key and selecting your event, it will build your tick list over here. Okay? This is going to tell us exactly what is contained inside that PDF that you've attached. Okay? So for everything in it, you should have an event. Okay? The docket entry with multiple events should look like this. Now the underline is indicating a separate event. Okay? So holding down the control key, selecting Schedule AB from the tick list, Schedule C, Schedule D, and so on. Okay? That's what we want you to do. Less submissions by your side, fewer submissions for us to review and to see. Single document entries, as a result of not holding down the control key, end up looking like this. Okay? Where you can see you have multiple entries. Okay? Multiple submissions on your part and also multiple QCing on ours. So we would prefer that everything be in one submission. All right? All right. Other miscellaneous filing errors. Excuse me. The name and the case number don't match on the document that you've attached. What we ask is that you get in the habit of opening up the PDF that you're about to attach to the submission and actually view its content. Make sure that it is the right case number and the right debtor's name, that it really is a notice of appearance and not a proof of claim. Okay? Because that's probably our #1 issue. Another problem that we recently noticed, filing payment advices for debtor 2 when there is no debtor 2. It's a single debtor case. So when you are making a submission for any document, you do not want to select debtor 2 if there is no debtor 2. It creates edits that we have to make. Okay? It's also confusing when people will be looking for that second debtor that really doesn't exist. Okay? Missing the name or case number on Chapter 13 plan. When you file a case, you have to file the plan the same day. If it comes in on a different date, you must have the name and the case number appear on the front of the plan. Otherwise, it will not be served. Okay? So, again, file your plan timely, and you won't have to worry about that. Failing to redact documents prior to filing. So, review your documents. We all are familiar with the items that should be redacted, personal identifiers. Unless you just like filing motions and like to pay fees, for filing those, just be in the habit of, checking those before you do that submit. Because otherwise you can have to file a motion and pay the fee to redact. Okay? And hopefully, on this last screen, hopefully you will find these links to be helpful. This is the link to the Green Eye Online Procedures Manual. This is something that may be new for many of you. Gail wasn't. No, you do. You use that. Okay. Because we have a number of you that have questions, we wanted to have a better setup on the help desk. We now have an email help desk group. Okay. So if you would email your questions into this group. There's about 4 or 5 of us that can then look at that email and jump on it. It allows us to have your questions answered while we're here doing things like this. There's an office that can answer them. So hopefully you will find that to be helpful. And here's a list of frequently asked questions. And the last 2 items here are how to get in contact with Lori or myself. And that brings us to the end of our section. So what questions do you have? Yes, ma'am.
So if you're adding a creditor, I think you were somewhat standing from the perspective of I'm the lawyer representing the creditor.
Yes.
If you're a lawyer representing the debtor, for instance, you're going to add the
Okay.
and they're going to be the defendant, you get add the creditor. So if you don't see one list that has the correct address, then you would create.
Then you would create, yes, very good example of when you would create.
If you find one with no address, you can edit that.
Yeah, exactly. Take it, make it your own. Yes. Did you have a question? Okay. All right. Well, if you think of questions when you get back to your offices, and I'm sure that will happen with some, just give us a call. Use the contact, the email help desk. We will respond. Also, this is being recorded, so anybody who wants to go back and review it, it is paid. So, anything else? Okay, thank you.
Just one final thing too that may help you.
You're on a fixed income. How much debt would you say you had between credit cards and loans and things like that? How much debt would you say you had total?
Oh, you want to take the picture?
Okay, so you have a whole lot. Yeah, I mean, a bankruptcy, a Chapter 13 bankruptcy could definitely help you pay that debt back, and make the payment, every month more affordable since you're on a fixed income. How much is your Social Security cost?
At least they're talking about that.
Okay. Do you have any other sources of income in the household? Okay. Yeah, I mean, bankruptcy could potentially help you out. We offer a free consultation. If you want to set up an appointment and come in and sit down with an attorney, we can kind of go over everything with you and determine whether or not maybe a bankruptcy would be an option for you. Is that something?
Well, first of all,
you can also go to the Bar Association website, has people's attorneys' email addresses.
Would it not be simple to put it on the forms? Are we talking about Chapter 13 trustees or Chapter 7? Either one. Either one. I think there was a lot of discussion about that with the new form when they came out in December of 2015. So we'll first say that with the 13 trustees, you can get these emails off of the website. Correct. And I understand this, but to your point with on the notice in the Chapter 7 world, many times our Chapter 7 trustees are also associated with firms and other parts of their work, and so there was concern about if there was on the website. Am I correct, Dale? I believe this was part of the discussion.
I don't know. I believe that we were either going to put email address or a website, one or the other. And I don't know if that's happened yet, but it's in the works.
And so for the 13 trustees, the website is there on the notice. You have to call. They have to have someone to answer these calls. It takes so much time. Just providing the email address. Like, well, give it to you. Again, I think that there was concern. That's why we put the website for the Chapter 13 trustees on the notice. There was concern about so many times the questions were targeted. What was the best address to have? So that's the best answer I can give you for 13. The 7th is still in the works. But I will say this is just a quick thing. As Dan was talking, there were 2 categories, right? The events that he talked about, amendments to DE&F, that really have a great impact, significant impact on you if you don't get them quite right. And so that, as well as identifiers, you want to avoid them to pay that fee. So how many folks use their train login to practice this? You know that you can have a train login, and so you can contact Dan and Irene for that. So with that amendment to DE&F,
have a train.
That's an event that we spent a lot of time working on the prompt to hopefully make it easier for you. And so I encourage you, if you don't have a login that allows you to test and play in TNECF, to get that login from Dan and Laurie, because you can go through and use that as then and look at these prompts to see exactly how to do that. That's true also with things like the identifiers. So that's another tip in addition to the little green eye, which we are really ambassadors for that because we spend a lot of time on it, and those that use it you really like it. So think about using your train login as well.
And I know I've used the ECF help desk, and I get a response within an hour. I mean, I am amazed. And one that I had an issue with Friday is I didn't know now when you file an adversary, you used to get your summons back immediately so that you could send it right out with the complaint. Now I understand that you all review it to make sure it's correct. So the summons in my case was issued like the day or 2 days later, and you have to be careful because if you've already served your complaint, you need to file another certificate of service with your summons. So be really careful with that.
And it's found under complaint and summons.
Right.
Under adversary.
Right. But I was like, I saw my complaint and I kept looking, so I finally sent it to the help desk. Where's my summons? And they explained, we're reviewing your work. I'm like, okay, whatever the process is, but which was new to me.
Well, I'll tell you what happened. We stopped doing these summons automatically because we ended up having to regenerate a second summons because the way the attorney would enter the name of the plaintiff and the defendant didn't match exactly the way it was on the complaint. So we'd have to go and fix that and then reissue the summons, and then it was difficult to tell which summons to serve, or if you've already served the first summons, you'd have to go and serve the second. So that was just easier to do it that way.
But honestly, I sent an email, where's my summons? And within 30 minutes, I had an explanation, which was really worked well. Anybody else have a question for what we've gone over so far? Okay, I'll turn it over to Alex then.
Okay.
Thank you. And everything will be available on the clerk's website, and I understand if you signed up with your email, they will email you all the slides tomorrow. Is that right, Fred?
That's right.
Okay.
Hi, everyone. Alex Alhansick, debtor's lawyer. I'm the current state chair for NACPA. I want to point out 2 or 3 things in the schedule that are pitfalls for my clients, how to avoid them, how to get rid of some of the issues that might come up post-filing. And the only way to do that is to do your due diligence before you file your case. It's important that you take your time on your intake. I've learned from my practice that you can't take enough time on your intake. The more time you spend on the intake, the less time less issues you're going to have afterwards. But you're going to get a notice. Somebody's going to point out some error at some point. And the best case scenario, if somebody points out an error, is that there's going to be a slight delay in your case and you go fix it by amendment. Worst case scenario, depending on the issue, your case is going to get dismissed, your client may get a denial of discharge, or the worst thing for my clients, they're going to lose some property. They hate losing property. So do your due diligence before. Whoever is in charge of that, sit down, make sure they take their time on that. The worst thing that could happen is you're sitting at the meeting of creditors table and they'll ask your client something that's not in the schedules. We expect questions about things that are in the schedules to clarify this point and that point, but that meeting of creditor room gets really quiet when the trustee asks you about something that's not in the schedules. Sometimes you can avoid it, sometimes you can't. But the first one is lawsuit versus cause of action. Most of our clients know what a lawsuit is. They've been sued. They bring the pink service sheet into your office, and you enter that on the Statement of Financial Affairs Question 9. No-brainer there. It gets murky because clients don't know what a cause of action is. We do, or hopefully we do. You've got to talk to them about what a cause of action is. If you discover that they have one, that's going to go on Schedule B number 33. And you can't just fly through these questions on the intake. You've got to take your time. You've got to ask 2 or 3 questions, give your clients time to answer, take a pause. But once you discover that, put it in the schedules. You have to remember that if your clients don't disclose a cause of action, they may be prevented from bringing that cause of action in the future. It's very important that gets listed. I had a client come in a couple months ago. We're doing the intake. She has a stack of credit cards and a small stack of medical bills. And she's talking, and I'm flipping through the medical bills, and I glanced at something, and the doctor had written down a note about a mesh defect. She didn't know she had a cause of action, but I watched enough of late-night lawyer ads to know that there's mesh product liability lawyers out there. So that must be a cause of action. Did she have a cause of action? I don't know, but it doesn't matter. We put it in the schedules that preserved her cause of action. Does your client have an interest in property, and should you trust what your client says? I don't. Is everybody familiar with the GSDCCA? Use it. I had a client. I asked if they own real estate. I've had to go both ways. I had one client say, yes, they own real estate. I checked with GSDCCA. She had transferred the property 20 years ago to her Aunt Betty. No problem. I had another guy say that he hadn't owned real estate in 7 or 8 years, and I asked him, well, tell me about that. And he said he co-signed for his daughter. She put a half interest in his name. And a few years later, she asked for him to transfer it back to her, which she did. So he comes to my office and says he doesn't own any real estate. If I take his word for it, somebody's going to lose some property, potentially, if there's enough equity in it. So I did a GSDCA search, and it turned out that his daughter had transferred the property back into his name 2 years before he came to see me without telling him. Fortunately, we did a GSDCA search, and we found that. You want to know about this stuff before you file. Like I said, there's nothing worse than somebody as a trustee asking your client about something that they didn't disclose. Fortunately, there was enough exemptions that we could use to exempt the property. My client could go ahead and file. But if we had filed without knowing something, it could have gotten to the point where somebody lost some property. Don't want that. We've all heard this. Clients tell you that it's not their property, it's titled in their name, only for insurance purposes, or they don't want to tell you about a debt because it's a cosigner, they're secondary on the loan. We all know that's no. They have to list it, but they don't want to. They don't know, or they don't believe in their minds that that's something that should be listed in the schedules. So you have to take your time with your clients. If you take away anything today, whoever's in charge of your intake, go slow. Don't rattle off 30 questions at a time and expect your clients to take it all in. There's a lot of information that goes in the schedules. One practice pointer, I wrote a number at the bottom to remind me. I don't know, do any lawyers or law firms keep track of their time in a routine consumer bankruptcy case? Not many do. I did. My number is 86%. If you keep track of your time, you might know what your number is. That's the amount of time on my average case, routine consumer case, that I spend prior to filing a case. The higher your number, the more time you spend prior to filing, the higher that number is going to be. If you find that your numbers, if you don't keep time, you might want to just to see where you are. If you find that 50% of your time is done before the case is filed and then you're running around doing a lot of minutes after the case is filed, rethink your intake process. It's very important. So that's what I have.
Okay. I just have a little, because we have 5 minutes so that we can get you down to 1 o'clock court. I find as a trustee an issue often where there are different notices that go out, and I get different responses from the attorneys and also from the debtors. I know this is the old one, and the new ones look a little bit different. But this is one that I call the total one. This one discharges the debtor, approves the trustee's report and no distribution, closes the estate, and discharges the trustee. So this one basically says you got your good housekeeping seal of approval, you're finished, you can go on. So that means the trustee's not doing anything else. Okay. This one is a new one, and I think it's really important because this says order of discharge. And it's important here because it says the order does not close or dismiss the case, and it does not determine how much money, if any, the trustee will pay creditors. The importance of this and the distinction is that this might be where your client has like a PI claim, a mesh case claim, something that's ongoing that I have to resolve. but the debtor's entitled to their discharge. So they get their discharge, but your case is not closed. I get so many calls from, represented debtors. My attorney will not talk to me because my case is closed when all they got was the order of discharge. There's also this one, which is the order closing a case without a discharge, which is what will happen most likely because the financial management course and the certificate were not filed, which is kind of inexcusable at this point in our process. Believe it or not, this was in the middle of a filing, an amendment where they actually filed, and I've whited out everything, they filed the official Form 121 with the debtor's Social Security number in the middle of an amendment. Please don't ever do that or file your client's tax return for some reason. These personal identifiers, we're trying to be really careful about not disclosing those. This one I thought was really kind of interesting about some of the inconsistencies and misinformation. Here, poor George and Melissa, what is your current marital status? Not married, okay. And then again, on another page, statement of current monthly income, George and Melissa are filing jointly, but they're still not married. Obviously, someone didn't take enough time. And what always amazes me is, do the debtors not actually read what is put before them to sign? Because you would have thought this would have been a very simple mistake to correct.
Maybe they thought this was a cheap divorce.
No, yeah, it was your case. You're going to grant them the divorce. I whited out as much as I could. There are also a lot of other inconsistencies, like if you say that they are a business debtor, tell me what the name of the business is, and also, or if they have an interest in a company, schedule that on Schedule B. You know, you've got a category for that, so let's get it listed. There's also a lot of discrepancy and inconsistency, whether they're consumers or business. In one place you'll say consumer, in another place you'll pick that they're a business one. There's also dependents or not, Schedule J number 2. The number that you list is often contradicts Form 122A number 13, the household size. Okay, it's 12:45, so I promised that everyone could be to their 1 o'clock hearings. Really appreciate everyone coming, and if you have suggestions for other topics that you'd like to present, you can contact someone with the Bench and Bar Committee. We've got some